would like to give the opportunity for our Polish contributors, Professor Aleksander Stepkowski from University of Warsaw, to deliver his speech, his presentation about the situation in Poland. Professor, the floor is yours.
Thank you very much, Professor. Well, I would like to focus on actually two case studies, one from 2010 and the other from 2021, which are both about constitutional identity. One was defining the concept of the constitutional identity in Polish constitutional law, and the other one was trying to implement this concept in action. And we will see what will happen in the future after this trying to bite, not only to bark. The problem of constitutional identity touches the very essence of European integration, first of all, when considered from the perspective of national constitutional order. However, the earliest context when the concept of constitutional identity has appeared had no connection to European integration, at least in Poland. It emerged in the context of judicial procedure and was referred to judiciary. Constitutional identity of the judiciary was understood as a complex of features peculiar for courts and legal procedures which ensure identity of judicial power as a distinct and independent, as well as enabling courts to administer substantial justice and not becoming over-formalistic institution. This already allowed for some thinking in terms of the essence of particular branch of power. However, it was still far from thinking about constitutional identity as perceived in terms of national sovereignty and its protection. The further development of the concept of constitutional identity in Polish constitutional law appeared, however, to be strongly related to the European integration, and in particular the issue of the limits within which sovereign power is transferable to the European Union. Poland joined the European Union, as well as Hungary and other countries from the region, on the 1st May 2004, 7 years after adoption of Polish constitution from 1997. This is an important issue because the Article 90 of the Constitution expressly provided formal base for joining European Union. This constitutional provision in the first section of the article reads as follows. The Republic of Poland may, by virtue of international agreements, delegate to an international organization or international institution the competence of organs of state authority in relation to certain matters. What is important here is qualification of the state competence subject to delegation by words to certain matters. As those transferable matters are only certain, they are not all. The question thus arises if there are competences which are unalienable upon this constitutional provision when read a contrary. In such a way, a constitutional concept has emerged according to which there are some inalienable competences of the state, which are to be described as the features of the Polish constitutional identity. The issue was addressed and concept was elaborated in the judgment of the Constitutional Tribunal reviewing constitutionality of certain provisions of the Lisbon Treaty. I mean the judgment K32/09 held on November 24 in 2010. In this judgment, some general theory of European integration as regulated in Polish constitution has been elaborated, and it is still in force. Constitutional Tribunal declared that whereas joining of the EU must result in a certain limitation of states' sovereignty, by no means it amounts to its abolishment, as the limitation is compensated by the power of co-deciding within the European Union. Moreover, according to Constitutional Tribunal, joining of the European Union, as it took place according to the Constitution, must be understood as a manifestation of national sovereignty and hence reaffirms primacy of the Polish nation in deciding about its fate. This basic principle is manifesting itself in the preamble to the Constitution, as well as several constitutional provisions, Article 2, 4, 5, 8, 90, 104, and 126. In those provisions, sovereignty is manifesting itself as a bundle of several inalienable states' competences, envisaging values upon which Polish constitution has been founded and determining constitutional identity of the Polish state. Therefore, according to Constitutional Tribunal, the concept of constitutional identity consists of the range of states' power which are non-transferable pursuant to Article 90 of the Constitution, which was quoted in the beginning, and thus they are untransferable at all. The matters covered by this absolute prohibition of transfer, so this eternity clause, let's say, include in particular protection of human dignity and constitutional rights, the principle of statehood, the principle of democracy, principle of the rule of law, or Rechtsstaat, the principle of social justice, principle of subsidiarity, as well as prohibition of the transfer of constitutional authority and prohibition of the transfer of competences to create competences. So competence. So in such a way, the Article 90 of the Constitution authorizing prima facie transfer of some competences to EU appears to be also the warranty for the preservation of constitutional identity of the Republic, as it sets the limits to the transfer of competences set out therein. What was emphasized by the Tribunal is that the Article 90 of the Constitution cannot be understood in such a way that it exhausts its meaning after a single application. It is inadmissible to consider that the initial transfer of competences to the European Union, as it took place pursuant to the Lisbon Treaty, gives an open way for further transfers, already disregarding requirements set out in Article 90. Those requirements still apply to future changes in the Treaty on European Union, if those changes result in the subsequent transfer of competences to the European Union. The concept of protection of constitutional identity is rooted in the protection of the national sovereignty, considered as a fundamental constitutional value. The preamble to the Constitution understands sovereignty as the power to determine the fate of Poland and the Polish nation, determining the manner in which provisions of the Constitution concerning independence and sovereignty of Polish state are to be interpreted. On the other hand, the preamble determines also construction of the provisions dealing with European integration, so Article 9, 90, 91 of the Constitution. Therefore, Article 90 of the Constitution was construed not only as an authorizing transfer of competences from the state to European Union, but also as a setting limits to that transfer. So, as such, the Article 90, determining procedure for passing the law transferring competences, was considered as one of the special normative anchors for the protection of sovereignty, along with Article 8, which is declaring the supremacy of the Constitution in Poland, providing, as well as Article 91, providing for primacy of European law before statutory law, but not over the Constitution. All those considerations led the Tribunal to solemn declaration of the constitutional principle of protection of sovereignty in course of the European integration process. The principle requires respecting constitutional constraints for transferring competences within the process of the European integration. Those constraints restrict such a transfer only to some issues, requiring provision of proper balance between powers transferred and those which are non-transferable, continuously belonging to state as an essence of sovereignty. Among the powers essential to Polish sovereignty, Constitutional Tribunal listed, among others, power to enact constitutional provisions and to review complicity with them, power to determine judicial system, authority over the state's territory, control over the army and the public order and security the principle of the protection of sovereignty in process of European integration requires also that allowed transfer of powers can only be done by means of special legislative procedure as specified in Article 90 of the Constitution. Forbids also transfer of competences in universal or general terms, they must be specified. Forbids transfer of entirety of the most important competences, and denies any kind of implied authorization of the organization granted with states powers pursuant to Article 90 to extend that amount of the powers so granted. Extension of attributed competences is only allowed by means of international treaty properly ratified and authorized by means of procedure provided in Article 90 of the Constitution, including possible popular authorization within the referendum. While declaring the principle of the protection of sovereignty within the process of European integration, Constitutional Tribunal also emphasized that the principle protecting national sovereignty must be reconciled with the principles of favoring the process of European integration, as well as the principle of cooperation between states, as it was declared in earlier jurisprudence of the Constitutional Tribunal. However, favorable construction of European law must not lead to the results that would contradict express content of constitutional provisions or would be impossible to reconcile with minimal warranties as provided by the Constitution. Polish Constitutional Tribunal also emphasized that the concept of constitutional identity corresponds to the notion of national identity as declared to be protected in the first sentence of Article 4, subsection 2 of the Treaty on European Union. This allowed the Tribunal to qualify European Union as a structure that affirms national identity of member states. Si non è vero, è ben trovato. Therefore, Polish Tribunal emphasized that the Article 5, Section 1 and 2 of the Treaty of European Union has declared objectives for the achievement of which is declaring objective for the achievement of which the Union was established as additional limits to the competences conferred upon the European Union and not as a factor allowing for gradual extension of the competences originally attributed to European Union. According to Constitutional Tribunal, the concept of the European Union, as expressed in the Treaty of Lisbon, aims to respect both the principle of preservation of sovereignty in the integration process, as well as principle of favoring the process of European integration and cooperation between states. Constitutional Court expressed its conviction that fundamental principles of the Union, as enacted in the Treaty of Lisbon, forbids such an interpretation of the treaty provisions which would aim at overruling national sovereignty of states or at jeopardizing national identity in order to take over directly non-transferred national competences. The treaty, so understood, explicitly confirms that importance of the principle of preserving sovereignty in the process of European integration, which is fully in line with the culture of European integration as included in the Polish Constitution. Therefore, the challenged Lisbon Treaty provisions were held to be conformant to the Polish Constitution. So, the Constitutional Court was barking, but very loudly. I have referred to the position taken by the Constitutional Tribunal in 2010, when Constitutional Court was very vocal on protecting, so it was barking on protecting national sovereignty within the process of European integration. It was easy to be so, as the judgment was affirmative for conformity of Lisbon Treaty to Polish Constitution. However, in 2015, political change took place, and the new political coalition started ambitious reforms, including profound changes in judicial system. The last resulted in a regular political war between judges representing the old judicial system and its political reformers, including new judges. No need to say that political constellation dominating European institutions by no means was enthusiastic about the political change in Poland. I am not going to present here even a brief outline of this conflict having its specific propaganda and political narratives. Enough to say, it resulted in a series of preliminary referrals to the Court of Justice of the European Union, as well as applications to European Court of Human Rights, which were used by the militant judges as a way to frustrate political reforms. Subsequent series of the judgments of the Luxembourg Court, at least to a certain degree, met the expectations and provided those judges with efficient tool for disregarding several statutory provisions. Those preliminary, not only statutory provisions, but also the judgments of constitutional courts, so the rules which have the range of constitutional provisions. Those preliminary judgments were touching directly organization and structure of judicial system, hence the competence never attributed to the Union, and which was subject to the exclusion from those matters which are transferable to European Union. Moreover, they authorized to disregard judgments of the Constitutional Tribunal and constitutional provisions by the common courts. Therefore, the issue of constitutional identity appeared suddenly as a resulted in the application submitted by the Polish Prime Minister to the Constitutional Tribunal, addressing the recent development of the Luxembourg case law and its relation to the Polish constitutional identity as determined by the Constitutional Tribunal in 2010, so in the judgment I have described earlier. Formally speaking, this application has challenged several provisions of the Treaty on the European Union. In substance, however, Tribunal has acknowledged that it is by no means the very treaty provisions which are at stake, but some specific way of their construction, as provided by the Court of Justice of the European Union in the recent judgments. On 7th October last year, 2021, the judgment K3/21 was delivered and provoked much of controversies, both in Poland and abroad. It declared inconsistency of challenged treaty provisions or specific way of their interpretation with Polish constitution. In fact, so the tribunal started biting, or at least it wanted to bite. In fact, these are not treaty provisions which are important here, but the effect of some very intensive interpretation that has been clearly envisaged already in the operative part of the judgment. It refers directly to the effects of the process of creating ever closer union between European nations, in the course of which European integration reaches the new stage, manifesting in adoption of legal solutions outside the scope of attributed powers and undermining constitutional identity of the member states. This is the wording from the operative part of the judgment. This judgment has 3 points. In the first point, it was held that, contrary to the Polish constitution, is EU law, precisely the EU law as constructed by the Luxembourg Court, which authorized European institutions to act beyond the scope of competences attributed to them upon the treaties, so ultra vires. Then, similarly, contrary to Polish constitutional, is EU, which undermines position of the Polish constitution as a supreme law of superior force and priority in application. Then, contrary is also EU law which prevents Poland from operating as a sovereign and democratic state. That should be read as preventing Polish parliament from legislating in the area which was not transferred to the competence of European Union. The second point of the judgment refers to Article 19, Section 1, which was held unconstitutional insofar as it grants national courts with the power to disregard provisions of Constitution in the adjudication process. Then, when it grants national courts with the power to apply statutory provisions that are no longer in force, being repealed either by the Parliament or by the Constitutional Tribunal when declared unconstitutional those provisions. In the third point, Constitutional Tribunal held unconstitutional EU law conferring ultra vires on national courts power to review legality of the procedure for the appointment of judge, be it the legality of resolution of the National Council of Judiciary or the very act of appointment of a judge by the President of the Republic taken directly upon the Constitution. Power, then, it is also contrary to the Constitution, the EU law conferring ultra vires power to decide that due to the defect with the process of judicial nomination, refusing to recognize such a judge as being appointed to judicial office. A brief comment here on the third point is necessary. Polish law provides for judicial review of legality of resolution of the National Council of Judiciary. In this point, the judgment challenged not the very legal possibility for reviewing resolution of the National Council of Judiciary, but granting this to the European law and not to specific court which is competent in this area, but to all the courts. Polish law forbids, however, to change the very decision on judicial appointment as taken by the President of the Republic directly upon the Constitution pursuant to the motion by the National Council of Judiciary, because it would breach principle of judicial irremovability. Once judge is appointed, should be irremovable. So the judgment of the October 2021 provoked much controversy. However, it seems to be quite simple application of the principle of protection of constitutional identity in the process of European integration as declared in 2010. And the judgment of 2010 caused not controversies at all. We don't know yet what will be the further development of the situation. I believe, however, that the situation requires some solution which will be rather political than legal. Thank you very much.